Claudia, let's let her in. How are y'all?
Good morning, Your Honor. Well, how are you?
Good morning, Your Honor.
All right. Is everybody here that we're expecting?
I believe so, Judge.
Okay.
Yes, Your Honor.
And we're here on 003-1012-2020, and we're here on a motion to strike controverting affidavits, I believe. Is that right?
Yes, Your Honor.
And I have read the motion. I guess probably I'll start with who you are and who you represent for the record.
Your Honor, my name is Valerie Holz. I represent the plaintiff, and this is my motion to strike the controverting affidavit.
Okay.
Kyle Smith on behalf of the defendants.
All right. You can offer whatever you wish to offer this time.
Your Honor, this is my motion to strike the controverting affidavit filed by chiropractor Dr. Jonathan Woodward. And the basis for our motion is that he is not a qualified expert as is required by the statute, section 18001, because he is attempting to controvert things beyond his practice scope. Specifically, he cannot, as a chiropractor, controvert nerve conduction study that he is trying to do. He cannot controvert the physician interpreting the nerve conduction study, a medical doctor, Robert Salmon. He cannot controvert a nurse practitioner's medical practice nurse practitioner, Kimberly Player. And also with respect to the chiropractor, where he is trying to controvert, his entire opinion is completely groundless, baseless, and sets arbitrary dates in the middle of treatment of the patient, does not provide any legitimate reason for that date, does not provide any explanation for that date. Dr. Woodward only authorizes 9 chiropractic visits without any explanation to where that number came from or why he decided that particular date all treatment should have been cut off. That date is less than 3 weeks after the accident. He believes that the patient should have been sent to home care instead of to perform home exercises at home, as opposed to attending chiropractic visits at the chiropractor's office, again, without any explanation or substantiation for those conclusions. That, for these reasons, we're seeking to strike his controverting affidavit.
Give any response to any of that?
Yes, I do, Your Honor. I respectfully disagree with counsel's position. My counter affidavit is roughly 6 pages of substantive materials that the affiant provides. It looks like to me in the beginning of her motion that not only is she trying to strike the counter affidavit itself, but her motion's entitled to strike the counter affidavit as well as to exclude his testimony. So I guess I'm a little confused. I mean, it looks like to me she's not only trying to strike the counter affidavit, but trying to potentially exclude his testimony if I were to take his deposition or to bring him live to trial. As far as the first part of the argument in her motion, she talks about basically the burden it would be on her to bring doctors to come and to testify if the counter affidavit is upheld. And I would say to that, Your Honor, that I'm willing to do dueling affidavits agreement if she's willing to do that. I'm not interested in trying to incur cost on Ms. Holz or anything like that, but I do believe that I do have a valid counter affidavit. And the reason why a counter affidavit was filed is because 99% of the treatment in this case was $16,300 in diagnostic charges alone for what we argue to be a minor MVA. $8,385 was in chiropractic treatment. She's saying that my guy is outside of his lane and opining on diagnostic imaging. And so first of all, the majority of the treatment in here is chiropractic services. The nerve conduction study was a referral from a chiropractor from where the plaintiff was treated. And the nerve conduction study was actually performed by a chiropractor themselves. So I'm a little confused as to why she's saying that we're controverting a medical doctor's opinion or we're controverting some MD. We're not. The referral was from a chiropractor. My guy talks about that there shouldn't have been a need for a referral. He provides an explanation for that. The other part of her argument is that it's conclusory, and she cites Turner v. Peril. And just briefly to distinguish Turner v. Peril from these facts, Your Honor, is that Turner v. Peril, the controverting affiant there didn't specifically identify the things that was being controverted. He didn't provide a reasoning for the controversion, and he basically generally rejected all of the treatment in that case. So this is not the case. In fact, my affiant says that, yeah, there's probably some injuries from this accident. Yes, some of the treatment was warranted and necessary. So it's completely distinguishable from that case. It's not conclusory. He actually cites the literature in the affidavit itself. So sometimes I hear the argument that, well, there's no literature, there's no treatise cited, there's nothing. I mean, he provides a basis for where he comes up with his opinions. And I don't want to read the affidavit to the court because I know the court, has time, doesn't want to take time to do that. But I feel like it's certainly justifiable and that it should stand.
Any last word?
Yes, Your Honor. As counsel pointed out, the chiropractor is not in his lane as the nerve conduction study that was interpreted and read by a medical doctor, Dr. Robert Solomon. As far as also the chiropractor is not in his lane as to the physicians, as to nurse practitioners who works for a physician's office, not a chiropractic office. Again, I stand by my Dixon argument that the controverting affidavit is not specific enough, and the date of 9 visits or 3 weeks is completely arbitrary, considering that the records also show that it was right in the middle of treatment and patients still had significant pain at the time. Also, I would call to Your Honor's attention that previously to today, other courts in Dallas, Court 4 and District Court 44 has struck this similar controverting affidavit by the same provider. Thank you, Your Honor.
Anything else?
Yes, Your Honor, just real briefly. As far as that it's conclusory, I just want to take one small little paragraph and read it to the court to explain why my guy was justifying his position. On page 4 of the counter affidavit, midway through the page, it says, there were several gaps in treatment where the claimant did not seek follow-up treatment on September 5th to September 27th, November 8th to December 6th, and to December 27th. It appears based on pain management records dated October 28th that the claimant had minimal to no pain and was asking to be released from pain management with the stated expectation that he would be released from chiropractic treatment as well. However, the records indicate the claimant was not formally examined or released by Dr. Fure, spelling F-U-G-E-R-E, until December 27th, 2019. So that's just one example of many that he provides a basis for his opinions. As far as to the diagnostic issue, on page 5 at the top of that page, it says on August 29th, 2019, the claimant appears to have received diagnostic ultrasound as well as nerve conduction velocity testing of both the upper and lower extremity, and there was no prescription for either of these tests. However, documentation does list that Trevine Fure, DC, as the referring physician. There was no examination service proximal to this order, hence no clinical rationale that would support the medical necessity for either of these tests, totaling $16,300. Of significance, the ultrasound indicated that the test was essentially unremarkable of the neck and upper back, and the nerve conduction velocity indicated some motor and sensory changes to the hands, to the left median motor, to the right median motor, and the left ulnar sensory nerves. This was not consistent with the claimant's complaint of right shoulder pain, nor was it consistent with the examination findings described on the initial chiropractic exam on July 8th of 2019. Second paragraph. Furthermore, this test was performed by Michael Hennings, DC, and his impressions indicate that was given the remainder of these data. These findings may represent artifacts, and I'll stop there. So the referral was from a chiropractor for the diagnostics. The diagnostics was performed, the nerve conduction study test was performed by a chiropractor. So I don't understand the argument that he's opining on something that wasn't performed or referred by a chiropractic healthcare provider.
Your Honor, if I may respond.
Yes, sure.
The purpose of the controverting affidavits is reasonableness and necessity of charges. This is about charges. This is not about reasonableness and necessity of referrals to other providers. If a chiropractor refers to a different provider, such as a nerve conduction, such as pain management, that does not authorize the chiropractor to issue an opinion as to whether or not those providers' services, as they performed them, and those providers' charges, as they charged them, were reasonable. That would be completely outside of Turner v. Pearl. Just because a chiropractor makes the referral, it does not give the chiropractor now the authority to decide how much that service should be for. That also would apply to any other provider who is referring for things like an MRI or nerve conduction or anything else. The facilities charges, the interpreting radiologist charges, those charges are completely beyond the scope of the chiropractor's training or experience and the requirements of the statute 18001. As to the argument that Gibbs and treatment somehow support his position, Gibbs and treatment go to causation, not to reasonableness of the treatment being rendered. That issue is also completely beyond the affidavits. So my position is that these affidavits are improper. They impose an arbitrary date that the treatment should stop 3 weeks after the accident. And when the patient's complaints are still 5 out of 10, and that they're completely unsupported and beyond the permissible scope of the statute.
Anything else?
Again, Your Honor, the affiant is not attacking the charges of the nerve conduction study. He's saying that it's not necessary at all. The referral's not necessary at all. And again, the individual who performed that study and the facility that performed that study was a chiropractic facility. So he's totally within his lane to be able to opine on those things. And she keeps saying that he's throwing out arbitrary dates. Well, I don't want to waste your time, Judge, but I mean, if you read the affidavit, he provides an explanation why those dates are what they are. I mean, I don't understand. What he's controverting is therapeutic activities. He's controverting ultrasounds that were performed by chiropractors. He's controverting the therapeutic exercises. I mean, he's not even talking about the pain management. I mean, he's simply talking about the referral to the diagnostics that were performed at a chiropractic facility by a licensed chiropractor who was not a medical doctor.
Here's what I'm going to take it under advisement. I'm going to reread everything, but I think I've read it before. And then I will, did both of y'all file orders?
I did, Your Honor.
Okay.
I believe we have to, yes, Your Honor.
Okay. I will sign one of those orders by tomorrow. And,
Okay.
all right.
Thank you, Judge.
Good luck. All right.
Thank you.